This morning in the newspaper, there was a story in the Las Vegas Review-Journal that cited an ethics complaint complaining about conduct relative to me, alleging that I had done something inappropriate with respect to my questioning of a marijuana licensing facility. I've reviewed the complaint several times. I view it as a nonsensical complaint. It's unclear to me exactly what these proponents are alleging that I even did wrong. But since lack of disclosure seems to be a part of that, I'd like to take an opportunity to explain what I gather they're complaining about in their poorly crafted complaint and what I've done. The essence of the complaint that I believe all the other commissioners were CC'd on relates to essentially an agenda item that was attempted to be heard before this commission on November 17th of last year. That item was the second request for a 2-year extension of a special use permit related to a marijuana dispensary facility. The staff report related to that item is notable. It said that the originally approved plans for that facility depicted a 6,940 square foot retail cannabis store within an existing 9,454 square foot building. Original plans for that store showed only 6,940 square feet of retail space, with the remaining area of the building not a part of the use. That's essentially the same square footage and design review that was approved in 2017 and for which this applicant received a continuance in 2019. The staff report indicated that the revised plans were subsequently accepted to increase the area to 8,357 square feet, and that an additional application was recently approved to expand the area of the internal store to occupy the entire 9,454 square foot building. The staff report then concluded that using the criteria set forth in Title 30, the applicant had made little progress towards the approval of that original application, and that the applicant had applied for building permits in 2019, which were expired, and again in April of 2021, which were still under review. It also indicated that a Clark County business license had not been issued for the establishment, which couldn't be done until construction of the facility and any associated improvements as shown on the approved plan are completed and all other state and local regulations are met. That's the entirety of what we were presented in the staff report. That's what I was briefed on prior to the November 17th, 2021 meeting. Despite the representations by staff recommending denial of that extension at the 11/17/21 hearing, only days later, this same applicant obtained approval for a temporary certificate of occupancy and a temporary business license based on plans that now apparent to me were identified as Phase 1, depicting a 360 square foot room. There was nothing in any of the staff reports or any of the information that was brought to me prior to that that would have indicated this change. Despite that fact, these permits were issued and they were given full licensure. So in response to that, it was continued. The item was continued, never heard. We didn't vote on any extension. December 31st, after gathering as much information as I could through publicly available records, I sent an email to the district attorney's office requesting clarification as to how this could have happened, asking whether or not we followed our own provisions of our code and whether or not we followed the provisions of the Nevada revised statutes, and whether or not these approvals were in accordance with our own procedures. I received no response. That's all that's happened. We didn't have a hearing. We took no action. So it's unclear to me how asking questions in an email constitutes use of an unethical use of public office. The complaint alleges, furthermore, that somehow there was personal or professional gain on my part, and that I used my status to preserve lucrative, ongoing business relationships for myself or my law firm. I want to be clear on that part also. I've not billed a single hour at my law firm since I became a commissioner. I don't have any ongoing representation of those clients or any others. I'm furthermore of counsel at my law firm, which means that I don't share any of the profits of the firm to the extent that they still represent these clients, which they do, and continue to represent them on appeal. The complaint also alleges that somehow there may be unethical conduct and failure to disclose this litigation, and that perhaps I should have abstained on something. Again, we didn't take any action, so it's unclear to me what I should have abstained from doing. It's also unclear to me when I should have disclosed any previous relationship with dealing with marijuana issues. Despite that fact, I've conferred with the district attorney's office about my previous representation of these clients on just about every marijuana issue that's come up. They've advised me that there's not a conflict of interest. There could be the potential that I may have to disclose previous representation. But certainly with respect to this issue, there's absolutely no conflict of interest. And again, to this point, I've only asked questions. But I did represent a group of clients that challenged the state, and specifically the Department of Taxation, in the issuance of marijuana licenses. When the state issued its final round of licenses that are capped in the state, I sued the state, not any individual recipients of these licenses. We sued the state, alleging that they didn't follow their own procedures. And there are key provisions of that court finding that I think are relevant to this licensure. One, the court held after a full trial that the state engaged in arbitrary and capricious conduct which violated the law. Second, that the Department of Taxation created an unfair process. Third, that the Department of Taxation engaged in intentional and repeated violations of the law in favor of a select group of applicants. Four, that fair process was contaminated by preferential access and treatment. And five, that the Department of Taxation selectively discussed with select applicants key provisions of the competitive application. Those key provisions related to the application were not shared with all applicants. And importantly, the court found that by selectively eliminating some of the requirements of the law, including the disclosure of an actual physical address, which is where they were supposed to construct these marijuana facilities according to the application, the Department of Taxation limited the department's ability to adequately assess criteria that would relate to things as prohibited proximity to schools and other public facilities. And that's exactly what's at issue here with this specific application, that it would limit their ability to look at the impact on the community, the security plans, the building plans, and other material considerations that they were supposed to review. But the court took note in its finding and said that could be cured by local government review. It said the Department of Taxation is only awarded to that point conditional licenses, which are subject to local government approval relating to zoning and planning, and that the local governments may approve a location change of an existing license. The public safety aspects of the failure to require an actual physical address, therefore, the court concluded, could be cured prior to the award of a final license. That obviously didn't happen. Importantly, the Review Journal had a separate story in August of last year that I think is especially relevant here, and it also highlights why we need to focus on this issue. It was entitled, "Nevada Marijuana Licensing Focus of Federal Investigation." And in that article, it said the State Department of Public Safety denied a Review Journal request for records related to the then Director of Department of Taxation, Jorge Pupo, and its joint investigation with the federal government. It said the requested records are directly related to an ongoing criminal proceeding, and many of the records will likely be significant evidence in the criminal proceedings. It said the Department of Public Safety staff wrote the interests against non-disclosure at this time include, but are not limited to, the following: that the records are directly relevant to the anticipated criminal proceedings, that the release would undermine the rights of a defendant to a fair trial, and that the release would prejudice potential jurors in the anticipated criminal proceedings. So I simply asked questions regarding how these approvals can be obtained in an email that, again, I received no reply to. I've learned more about what happened in this approval process from the ethics complaint that was filed against me than I did by asking questions in my email to the district attorney's office. The staff report presented to me that I was briefed on prior to the November 17, 2021 meeting stated that plans recently approved to expand the area of the internal store to occupy the entire 9,454 square foot building. But according to emails and the ethics complaint against me, the staff report didn't inform the board of the full story. It appears that on November 2nd, 2021, despite the fact that the staff report indicated that the plans were contemplated a 9,454 square foot building, said that Thrive emailed the staff indicating that they wouldn't have time to complete the build out by the 2-year deadline, which was supposed to occur by early December. So they therefore submitted revised plan, reducing the facility to a mere 360 square foot room. They said they hope to complete that construction by November 20th, and after obtaining full licensure, they intended to move for full closure of that facility so that construction of the approximate 9,000 square foot facility could resume. Then, only 5 days later, on November 7th, their attorney, Amanda Connor, emailed again, indicating she was checking for reviews and sign-offs from county staff, and that she was hoping for final Cannabis Compliance Board inspection on November 20th through the November 25th. That would have required full sign-off from the county, issuing a certificate of occupancy and a business license, having done all the public safety inspections. Only 2 days later, November 9th, Dave Brown, on behalf of that applicant, Thrive, thanked county staff for an expedited review. On November 12th, there was yet another email from Amanda Connor asking for updates regarding sign-off. Ultimately, those sign-offs were apparently obtained. But the questions were asked in my December 31st email because it's still unclear to me what the benefit of these expected sign-offs and licensure of a building that's still under construction were. What is the public benefit here? We approved a 360-foot room. When this was originally approved and put in front of the voters, a primary justification for the approval of it was that the state could obtain tax revenue. Well, this facility was never going to be open. It was fully explained in the emails of staff. They didn't anticipate for this to be open. So certainly we weren't rushing to approve this so that we could get the tax revenue. One of the criteria that we were supposed to review in issuing these licenses was that the facility is of adequate size to meet the needs of the community. There are some patients that are medical marijuana patients that need access to marijuana. That again was used as justification for legalizing this, which is still illegal under federal law. And there's only a limited number of licenses, 80 of them. That's why that competitive process was put in place. So again, why would we rush to approve a 360 square foot room that never intended to be open?
Commissioner Miller.
Yes.
Could you wrap this up?
I'm wrapping it up.
Let me just say, I understand that you can't go around and talk to 6 other people because that violates the open meeting law. And so we're allowing this, but if you could wrap it up, that'd be good.
Sure. Thank you, Chairman. I'm, of course, facing an ethics complaint, which has serious implications.
I want you to be able to get in the record.
Since there was no opportunity, in my estimation, in order to be able to make these disclosures, that they've now gone to the media with an ethics complaint, which ordinarily would be confidential, and so therefore I'm trying to give a response.
I understand what you're doing.
Okay. I'll wrap it up. In short, I'm driving it trying to learn when we conduct public hearings on any of these marijuana facilities, and to learn why these were expedited, and to try to figure out whether or not we followed our own code or applicable law. And I'm going to continue to ask for answers to the questions that I've asked. Thank you.
Thank you. Commissioner Sagerblum.
Thank you, Mr. Chairman. A couple of weeks ago, I was joined by our county manager, Yolanda King, in a Shoes for That Fit event where we gave away 200 pairs of really high quality shoes.